Chirag, for you, the question is, Ferguson and Clanton seem like serious injustice. Are there applications to NYC? And I guess I'll just elaborate on that a little bit. You said that Clanton wasn't about bail schedules, but it was really about that the constitutional violation was a failure to inquire into the ability to pay. And listening to what we have listened to today and knowing what we know about the speed of the arraignment process that happens in New York, even in the absence of a lack of a bail schedule, I don't know if there is a proper inquiry in people's ability to pay bail as it's set in this city. So I'm curious, or whoever wrote this is curious about applications. For Judge Levy, the question to you is, how did the federal system move away from an assumption that you need money to get court attendance? And Renee, for you, the question that was posed was, how can the innovation of Project Reset be applied to a broader population like John and Jane Doe? So whoever of you feels most ready to handle your question can leap into it, and then.
Well, I'll start since you read mine first, Nick. So to the question of applications to NYC, I mean, I'll start by saying that this has really been a learning experience for me. I don't practice here. I don't know the city in the way you do. I lived here once more than 10 years ago and looked fondly on those times and hope they'll come again. But I'm going to have to defer to folks here about what the system actually looks like. But to the broader question of whether the 14th Amendment has an application outside of bail schedules, absolutely. In fact, we said so in a letter that we sent to every Chief Justice and every state court administrator in every state in mid-March this year. In that letter, we talked about abusive court fines and fees practices, but we also talked about bail. And in the bail section, we talked about this principle that comes out of this line of cases, and for the lawyers in the room, the Bearden case from 1983, that essentially said that it violates the Equal Protection Clause, that is the principle of equal justice, regardless of your circumstances, for otherwise similarly situated people, to send someone to jail, that is to deprive them of their liberty because of their inability to pay. And so in that case, in Bearden, the defendant had been charged with robbery and then fined $500 and I think $250 in restitution, and was making payments on that amount on time and sort of over the course of a certain schedule he had set for payments. And then he lost his job and he couldn't make payments anymore. And so he was called back into court and his probation was revoked and he was sent to jail. And there was no inquiry into whether his non-payment was willful, meaning that he actually could afford to, or for some other reason was essentially thumbing his nose at the law. And the court just said, you're not paying, the next step is to send you to jail. And the Supreme Court there said that that is unconstitutional. There you're treating people differently based on their wealth. You have to conduct an inquiry into their ability to pay. And our position is that that line of cases applies to the bail context. When you hear about bail, you often hear about excessive bail. So there's an excessive bail clause in the Constitution, and in certain ways it's been limited by Supreme Court doctrine over time. But this line of cases also applies, that is, treating people differently based on their wealth. And so, again, without speaking to the specific example of New York City, you guys would know better, if judges are not, in fact, conducting some kind of inquiry into this person's financial situation, into their ability to pay before they are setting bail, you may wind up with a situation where people are sitting in jail just because they can't make the bail. And actually, just one other thing. We saw on the slides at the beginning that, I think there was a slide that said 44,000 people are held on bail in New York City. If you just step back, held on bail doesn't actually make much sense as a concept, right? Bail is about release, not about detention. So I think there's sort of a fundamental reorienting that needs to go on in terms of what our system is meant to do. It's meant to be about release, except in those situations where people need other conditions on them. And I understand there's some limitations on preventive detention, but release with conditions to ensure their reappearance for trial, or the safety of the community in other places. And if you're setting the bail at a rate that somebody just cannot make, then you are no longer engaged in the process of sort of prudent release, you are preventatively detaining them. And there's a constitutional issue.
I just want to describe the process that happened to get to the launch of Project Reset, and I think that will help towards guiding us to an answer to that question. In 2014, August of 2014, the Brooklyn and Manhattan District Attorney's offices sat down with NYPD and CCI, service provider, Center for Coordinated Innovation. And at that time, we talked about the potential for this program, its benefits, what we thought there may some downfall may be, what charges should we consider, what age group should we start with, what precinct should we start with. And we started in August, and the program launched in February of the following year. And I say that to just say that we have been talking recently about moving the intake from 16 and 17-year-olds to 16 to 24-year-olds. One of the requirements, and it generally is to receive a desk appearance ticket, is that it is a first arrest. So everyone that we are seeing now, or CCI is seeing now, it's a first arrest, and that will remain so even for 16 to 24-year-olds. When you look at Jane Doe and John, it becomes a little bit trickier. I think John had 12 misdemeanor convictions, so I think that it would take a lot more discussion to determine who would be eligible. And I'm not saying that it could ultimately be ruled out. I mean, when you look at the Jane Doe case, there seem to be particular issues that came to light. Our deputy counsel from the Bronx DA's office said the fact pattern could elicit sympathy, because it was Similac and 6-month-old baby and so on. But I don't think that ultimately we would be prevented from looking at that kind of diversion for particular cases. But now it's it is first arrest. But I will say that I do get many phone calls from the defense bar, from my colleagues, ADAs at the Brooklyn DA's office, and even from judges that will say, I have someone 26 years old that was arrested for the first time. What is it that we can do? So clearly there is a need to look to expand those types of diversion programs.
Thank you.
The question was, how did the federal courts get away from cash bail? I don't know the answer to that. But I'm going to try to tell you why most of us are moving away from over-incarceration and pretrial detention towards release with appropriate safeguards. Number one is that the Bail Reform Act of 1984, which did add a danger to the community component to basis for detention, also emphasized that judges cannot detain someone if there is a condition or combination of conditions that could guarantee that person's return to court or the safety of the community. Well, those conditions are broader than money bail. They're broader than how much money someone has. And I suppose you could say that with the advent of more and better technology, we now have other ways to make sure people come back to court. I think we could easily say that all of our digital fingerprints are everywhere, and it's very difficult for any of us truly to flee and not to be apprehended. In the federal courts, we have the luxury of having the U.S. Marshal Service, which can go out and gets 9 out of 10 people who have fled. It's rare that people flee, and it's rare that they aren't caught. I think many of the judges began to feel at some point that they didn't want to be revolving door judges. In other words, that someone comes to court, the person is detained, the person convicted, does time, leaves the court, comes back for the same thing, and is worse off than the first time that you saw that person. Charles Sifton, Tony Sifton, who was our chief judge 10 years ago, started the first federal court reentry program. And one of the reasons he did that was, he said, I don't want to sentence somebody to prison and have that person come back worse than he was before. I don't want to make people worse. I want to find a way to make people better. And if you, again, you look at the arc of, or the trajectory of a person's appearance in court, whatever happens to them, either they're convicted or they're acquitted or there's a plea, we want to, from the beginning, from the day that people come through the door, we want to be sure that we're trying to do the most we can. Our job isn't just to apply the letter of the law blindly. It's to make sure that justice is done and that whatever supports can be given to people, whatever ways we can safeguard the community, they're followed. Also, there are more studies now than ever were done before. And I think doing studies like the Vera study and other studies tell us things that we didn't know. I mean, we know, for example, now that a person who is detained pre-trial is, if convicted, is more likely, or is likely to get a sentence that is 36 months longer than someone who is similarly situated who wasn't detained. Well, that means something. And it's not just because the person cooperated who's out, I mean, and getting so-called 5K1 letters, that's all been compensated for in the studies. So there is a certain unfairness to what happens to people when they're detained. Many times they need to be detained, but there are consequences to it. Finally, in our court, as judges, we see both civil and criminal cases. And there's the largest number of filings in our court, at least in the Brooklyn Eastern District, are police abuse cases, Section 1983 cases. Some of them are justified, some of them aren't. I'm not taking an opinion broadly on that. But when one sees over and over again cases where people claim to have been falsely arrested, and where the city of New York is settling those cases saying, well, yes, there was a mistake made here, it gives one pause when one thinks about whether those people were detained at Rikers Island. The most recent settlement conference I had yesterday involved somebody who was acquitted at trial after he'd spent 1,200 days at Rikers. You know, that's, it's a sobering thought. So again, that's something that I think judges in the federal system and everywhere are more and more aware of. So I could go on and tell you about our diversion courts. We have a diversion program for youth, for people under 26, and we have a diversion program for people with substance abuse problems. But again, I think you all in the state system have done a lot more with that than we have. We're latecomers to this program, but we really, really believe in it. And as DOJ has been leading the charge and the Brooklyn DA, we're very committed to trying to find ways to eliminate unnecessary pretrial detention, while at the same time ensuring that people come to court when they're supposed to, and that the safety of the community is safeguarded.